Hi.
Hello.
Hello.
Can you hear us?
Can you hear us? It's probably got a bunch of cases going on.
All right, so the record can be clear. Both parties have no objection to Officer Dixon appearing by Zoom,
That's correct.
and it's to get clarification or testimony in regards to whether or not Mr. Ross reached out to probation with any problems with his sobriety, and also to ask questions for whatever either side wishes to question the witness about. So there's no objections to the witness appearing by Zoom, is that correct?
None.
All right, Officer Dixon,
Yes, ma'am.
could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. All right, if you'll state your name for the record.
Tamia Dixon.
Miss Dixon, how are you currently employed?
I'm employed as an adult probation officer.
Okay. And in your duties as an adult probation officer, were you assigned to supervise James Ross Jr. as part of your case?
Yes.
Okay. And while supervising him, are you aware of who read him his terms of probation?
Yes, me.
Okay. And is one of the terms of probation that he is to report to you?
Yes, ma'am.
Okay. When is the last time, do you know how long or how frequently was the defendant supposed to report to you?
Once a month.
Okay. When is the last time that the defendant reported to you?
The last office visit was April 25th,
And what year was that?
2025.
Okay. And after that, had you spoken with the defendant, like on the phone or by any other means?
So his last visit was April 25th. And after that, I did not hear from him until June 9th, 2025.
Okay. And regarding the conversation on June 9th, 2025, without getting into the specifics of it, were you made aware of a warrant for his arrest?
Yes.
Okay. And what did you instruct him to do when you spoke with him on June 9th, 2025?
Once I spoke with the detective and he verified that the warrant was active, I instructed him to turn himself in and handle the warrant to clear it.
Okay. And to your knowledge, was that done?
Um,
Well, actually, let me rephrase the
okay,
question. Did you speak with the defendant again on June 12th, 2025?
June 12th. No, I do not have record of that conversation, no.
Do you recall ever speaking with him again after June 9th, 2025?
After June 9th, I talked to the detective, I talked to him. I didn't document it, so no.
Okay. Now, regarding the reporting that was supposed to be monthly, was that to be in person?
Yes, we were to report, he was to meet here in this office once a month on a date that I gave him.
Okay. And so any communication that you had with him via telephone, that would not satisfy the requirement for him to report to you in person. Is that correct?
That's correct. Unless I told him something like, oh, this can count, or we could reschedule, or anything of that nature, but that was not done.
Okay. Now were you made aware of any positive drug test regarding this defendant?
On May 1st, 2025, he did result positive for amphetamines and cocaine.
Okay. And so since you said the last time that you spoke with him in person was April 25th of 2025, between that date and the date that he tested positive and then the date that you spoke with him on June 9th of 2025, did the defendant ever report to you having a substance abuse issue which would require him to go inpatient or anything like that?
No,
Okay. Did he ever ask for any help specifically regarding substance abuse?
no,
Okay. And as far as the conditions that were in place for him, were you ever provided with any proof of completion of a parenting course?
let me check. I'm checking right now. No, I was not given a certificate of completion.
Okay. And then regarding any community service hours, did the defendant provide any proof that he completed any of the 200 hours that were assessed?
No, no completion was submitted.
Okay. We talked the witness, Your Honor.
Defense?
Um, I just wanted to get some clarification. You said there was a positive drug test on May 1st,
It was May 1st, yes.
and where does that drug test take place at?
He goes to either recovery downtown or he can come here on Mondays and Thursdays here at Bandera location.
Could you please tell us where that May 1st test was taken at?
Let me check and see. It tells me RMS, but I'm unaware if it's Bandera location or downtown. I just know that it's RMS.
And what does RMS stand for?
Recovery Medical Services or something like that. Yeah.
Is that the test provider?
Yes, that is. That's where they go and submit their drug test.
Okay, and so what you're saying is that your notes are inconclusive as to whether or not he came into your office in the month of May.
In the month of May, yes. I am unaware if he came here or downtown.
Okay, and when he comes to your office, I imagine he doesn't direct himself as to what to do when he arrives.
When he comes for a drug test, he's not to check in with me. He's only to check in with the drug test providers when they're here. So regardless, I wouldn't have known if he was here or not because he does not check in with me when doing drug tests.
Okay, were you available that day when he showed up?
I'm not sure if I was available or not. He didn't ask for me or anything. I probably was in a meeting.
Okay, fair enough. Now, my next question is, did you receive a call from him on June 1st?
June 1st. Let me check. No.
Are you aware of the offense date of the alleged, I think it's new number 1 in the MTR allegations?
Let me check the MTR. I have it pulled up. The alleged date is June 1st, 2025.
Do you recall speaking to James Ross about that new number one, the day that it happened? Did he call you or speak to someone at your office?
No, not on June 1st.
So my question to you is, do you document any and all communication with the client, or just those that you deem to be relevant?
All of them.
And it's your testimony that you did not speak with James Ross regarding his new number one allegation.
Not on June 1st.
When did you do that? When did you have that conversation, I should say?
On the 6th, the same day that I talked to the attorney about the case, it would be on the 6th. Because that's the same day I talked to the detective,
So then you talked to James Ross on the 6th, and then you also talked to him again on the 9th, is what you testified to previously.
So I talked to I talked to him and the detective on the same day, not the 6th, on the 9th.
Thank you for clarifying. And what you're saying is between June 1st and June 9th, you had no contact with James Ross.
No,
Did James Ross send you any documentation from his most recent number one allegation that the state is alleged in the MTR?
let me check my email. I'm checking my email as of now. No, the last email I received from James Ross was April 2nd, 2022.
Did he ever send?
I'm sorry, 2025.
No worries. So it's your testimony that he never sent you a Cash App receipt dealing with the new allegations that he was facing?
Judge, I'm gonna object as to outside of the scope. We've waived that, and she's not like a fact witness or anything, so.
Well, in response, Judge, we're here trying to establish whether or not he stayed in contact with probation, and that's the only line of questioning I'm trying to pursue.
All right, the objection will be overruled.
Again, did you receive a receipt from James Ross regarding his new allegation that was, I believe, a Cash App receipt?
Okay, it shows here. Actually, I have an email. After the 2nd, I received the email on 6/17/2025. Payment, please call the probation. It was a payment from Bear County. He submitted a payment towards his financial obligation on the 16th of 2025, and that was forwarded to me.
And what month was that again?
That was June 16th, 2025, and it was a payment of $34 towards his financial obligation.
Okay. So you spoke with him on the 9th, and then he made a payment on his probation fees and costs on the 16th?
On the 16th, yes.
And and you said that, and just to be clear, you said that the positive urine screen was May 1st.
May 1st, yes.
Thank you. No further questions.
Nothing further, Judge.
All right, is this witness excused?
Yes, Your Honor.
Subject to recall.
All right, does anyone have another witness?
Judge.
The defense would like to call Mr. Ross.
All right, could you rate, you're still under oath. All right, you may proceed.
Just one more. Mr. Ross, on the date of the new alleged number one against you, did you call the probation department or Miss Dixon that day that it happened?
I did.
Who was with you when you made that call?
Twanya Monday.
Who was Twanya Monday to you?
All right, first of all, for the record, if you could spell the first name.
TWONYA.
All right,
And what date do you recall speaking to Miss Dixon?
It was the date of the alleged robbery. I believe it to be the 1st,
The 1st of what month?
June.
Is that a 2025?
Yes.
When you called her, did you reach her directly or were you rerouted to her when you called a general number? How did that work?
I reached her directly. I called to the office.
Okay. When you spoke with her, did you identify yourself?
I did.
Did you communicate to her about your circumstances and what had just happened to you?
I did. Told her I was worried that I was gonna get in some trouble with this woman who was not trying to pay me for the work I done.
Now, without getting into the facts and circumstances of the case, why did you feel compelled to call Ms. Dixon on the date that this incident happened?
Because after me and my girlfriend left, I saw police shooting past us in the opposite direction from which we came. So I felt like she'd called the police.
Okay. And you wanted to, as a result, make sure that you talked to probation and let them know about this alleged incident.
Right, I did.
Now, after June 1st, when is the next time you spoke to Ms. Dixon?
When the detective contacted me to come to an interview with him.
And what day was that?
I don't remember the exact date.
Was it the same week as the incident?
I believe it to be, yes.
She's testified, I believe, that it was June 9th. Would you dispute that date?
No, I wouldn't dispute it.
Okay, sounds familiar to you?
It does.
Okay, and as a term and condition of your probation, you know you're not supposed to have police contact, correct?
Right,
And the detective will qualify as police contact. Is that fair to say?
it is.
And as a result, you wouldn't contact the probation to let them know about that contact.
I did.
Now, on June 16th, Ms. Dixon has indicated you sent her an email. Do you recall doing that?
June 16th.
Or whatever day you recall sending an email.
I do. That sounds familiar because I sent the detective the same copy of the receipt from the Cash App transaction. And then I also sent it to my probation officer so someone else would have it besides just the detective.
And again, we're not getting into the facts and circumstances of the case. We're just talking about communication.
Right.
And that email was sent around the 16th of June, 2025.
Yes.
Okay. Now, there was also some mention that you paid a fee. You recall doing that?
I do. I was trying to stay current on my probation fees.
Did you contact anyone at probation before you made the payment or after?
I don't recall
How did you make the payment? Online or did you go into the office?
online,
Okay.
I believe.
After you made that payment, did you hear from Ms. Dixon at all?
Yes, after she spoke with the detective. Next day, after she spoke with the detective, she instructed me that I should go and turn myself in.
Okay. And I'll leave it there. Thank you. No further questions.
All right, any questions?
Yes. All right, Mr. Dixon, so you're here, or Mr. Ross, you're here because you're on probation for possession of a controlled substance, PG11, or 4 to 200 grams, is that correct?
That's correct.
Okay, and so I want to take you back to May 20th of 2024 when you were placed under arrest for the offense that you're on probation for. Do you recall that date?
No,
Okay, and so that date, you were traveling in a motor vehicle, is that correct?
yes, it was not mine.
Okay, but you were in the driver's seat, correct?
Correct.
Okay, and you were with another person on that day that was in the passenger seat, correct?
Correct.
Okay, and so the officer pulled you over for a defective headlight, is that correct?
Allegedly.
Okay, well, you understand that this was stipulated to, correct? When you took the plea, you said it was true and correct. You remember that?
Well, Your Honor, I'm going to object at this point
Okay, go
for the
ahead.
simple fact that if he pled no contest, the court simply establishes a record. There's a basis to prove the case beyond a reasonable doubt. That doesn't mean he's agreeing necessarily with everything in the report.
Well, Judge, and I can ask him about it because it's part of the stipulations in the court's record, and it's going to whether he's actually a user, as they're claiming, or whether he had other intentions with the Controlled Substances Act.
All right, the objection is overruled.
Just really quick, I'm just trying to clarify so we understand. This line of questioning is about whether or not he's a user of drugs versus a seller of drugs. And he's on probation for using.
His estate waived the first count, so if I'm getting to blame my predicate as to what was found on him.
Okay, and he tested positive for drugs while on probation, which is used as well.
All right,
Users can.
the objection is overruled. The court will hear the question and the answer.
Okay. And so you understand that the officer stated that when he approached the vehicle that he smelled an odor of marijuana, right?
Understand that to be so.
Okay. And so when the officers searched your person, in your pocket, you were in possession of a scale, is that correct?
Allegedly.
Okay, if that's in the stipulations, are you now disputing or contesting that?
I don't recall.
Okay,
that day. It was like, lights blinded me in my face. I was snatched out the car and everything happened so fast. I really don't remember.
okay. And then after that, you were in possession of 13 grams of methamphetamine. Is that correct?
That's not correct.
Well, I guess let me rephrase it. It was actually 17, but by the time it got to the lab, it was 13, correct?
Well, Your Honor, I'm gonna object to that line of questioning because there's a field test and there's admitted labs through a state certified crime lab. Which one are we going off of? Because there's a reason
Well,
there's a state certified crime lab.
is he gonna answer truthfully or not?
But we're trying to figure out what the question is, the 17 grams or 13 grams. We're just going with whatever the
Objection
stipulation is.
is overruled.
So how much methamphetamine were you in possession of?
I wasn't in possession of any
So then why are you on probation for possession?
because I didn't want to lose my apartment that I just got and I wanted to be free. So I signed for something.
Okay, so help me understand this then. You're here asking the court for help because you have a drug problem. Is that what you're asking the court for?
I wasn't aware that I was asking the court for anything.
So you understand that you were here on a motion to revoke probation. You were present earlier before the lunch break, correct? And you heard the state asking the court to revoke you for 8 years. Is
I
that
did.
correct?
I
Okay,
did.
and you don't want to go to prison for 8 years. Isn't that true?
That's correct.
Okay, so what are you asking the court to do then?
To understand it. Like, hoping not to get revoked.
On what basis?
You're charging me with, you're saying that I violated or 2 things only out of the 10 that you put on there. Saying that I was charged with this frivolous crime because I was panicked.
I'm very confused right now. So are you saying that on the date of the offense that you're on probation for, that you had been under the influence of a controlled substance, but you weren't possessing it? Is that what you're saying?
Yes.
Okay. Moving on. So you were smoking marijuana then?
I think we need to, just for clarification, Your Honor, the word possession has a lay meaning and a legal meaning. And I think maybe that clarification is where the question.
No, I mean, you can
Fair enough.
recross. Or I should say redirect.
Okay, and so it's your testimony. I mean, are you disputing that Miss Dixon testified that the last time that she saw you, that she personally observed you in her office was in April of 2025? Are you disputing that?
No,
Okay, so to be fair, you never made contact with Miss Dixon in person after April of 2025. Is that correct?
that's correct.
Okay, but it's your testimony that you had called and made contact with some different people at adult
No, that's
probation.
not my testimony.
Okay, well, explain to me. Go ahead.
I called Miss Dixon and tried to reschedule my appointment toward the end of May, June. So I went in May and took a drug test to her office, but I didn't see her. So I made the payment and took the drug test.
Okay, so that's the drug test that came up positive, right? The one that was May 1st. Okay, and so you didn't report to Miss Dixon that day. You reported to the person that administered the urinalysis to you.
I actually did call her that day. And when I called her, I told her that, I'm gonna come take this test. I'm running late. So can I take it on the second half of the day? And I made it right before they left. So I was the very last person in there at like 5 o'clock. So when I showed up and they allowed me to take the test.
Okay. And then you heard Miss Dixon testify that on June 16th of 2025, you submitted a payment of $34 to probation, correct?
Right.
Okay, and you stated that that's because you wanted to stay current on your fees. Is that correct?
To show the court that I'm actually trying and I'm taking it serious.
Okay. And so $34 was the highest amount of payment that you could make at the time.
Because I wasn't employed.
So then how do you have money to test positive for cocaine and amphetamine?
I have one, excuse me? To test, it's
No,
$11.
to buy
I didn't
controlled
buy.
substances and invest them. How did
Assuming
you,
that I bought them, I just told you that a friend came and smoked with me.
so it's your testimony that your friend came to your home and bought methamphetamine and cocaine. And y'all smoked it.
I didn't know about being any cocaine, but I smoked meth then,
You smoked meth.
so it could have been in it. I wasn't aware if it was, I didn't snort no cocaine.
Okay, but you didn't financially compensate this person for the narcotics, is that correct?
No,
Okay.
didn't.
You understand that as a term of your probation, you're not to hang around with people that engage in drug use and have criminal records, correct?
No.
Okay,
It's not my intention to be there where I was under the stress of catching a whole aggravated robbery. That's the what.
but you didn't reach out to probation and tell them, hey, I'm feeling so stressed. I'm about to use, can you please help me? You didn't do that, right?
I called him and let him know I called that I was worried about a case.
Did you specifically tell them that you were so worried that you were going to ingest narcotics is the question.
No, but I
Okay,
went to.
thank you.
my-
And then regarding Tanya Monday, you stated that's your girlfriend?
Yes,
Okay, and she was with you on June 1st of 2025, correct? When you went to the alteration shop, she was with you?
yes, she took me. She asked her to bring me back.
Okay. We have to witness, Your Honor.
Just for some clarification. And this is an important question. You're saying on May 1st, when you went in for your drug test, you did speak to Ms. Dixon?
Yes,
Okay. And you're sure of this because you were running late that day and you ended up having to take your drug test later than usual?
right. I was supposed to take it the first half of the day because they come and they leave at 1:30 and then they come back second half until 4:30.
And if you miss your appointment or you don't reschedule, that's a violation. You understand that?
I do.
And so you weren't violated that day, were you?
I was not.
And so someone had to have allowed you to take it in the second half of the day rather than the first half of the day. Is that fair to say?
Yeah, they're only there on Mondays and Thursdays from.
My question is, the day that you came late,
Mhm.
you had to have permission to do that. Is that correct?
Yes,
Because otherwise, if you had not taken that test, you would have been violated, correct?
correct.
Okay, so somebody gave you that permission. Is that correct?
Correct.
And you're saying that somebody is Ms. Dixon?
She told me that I could come in and take it before they leave, but I must make it before they leave.
No further question.
I don't have anything further, Your Honor.
All right. Are you asking to recall Ms. Dixon? All right. Thank you, Officer Dixon. Court will hear argument.
Judge, so I'm re-urging the court to grant the state's motion, revoke the defendant and sentence him to 8 years in the prison because this is clearly a person that has no intention of being on probation or doing good on probation. Essentially, we've called Ms. Dixon here to just call her a liar and say that she doesn't document correctly and that what he is saying to the court is true, that he did reach out on all these days that are not documented. And then I take issue with the fact that he's not even taking responsibility for the case that he's on probation for. He stipulates that the stips are true and correct, and then he wants to come in here and say, I don't remember, it wasn't that much meth. It wasn't mine when it was found exactly where he was sitting, like, notwithstanding all of the testimony that's come today, the fact remains the same that probation has not heard from him or Ms. Dixon herself when he's supposed to be reporting monthly. Ms. Dixon has not seen him since April 25th of 2025. And that's an important fact for the court to consider because what is the purpose of defendants reporting to their probation officer? And so their probation officer can offer them assistance. So their probation officer can see, are they under the influence of narcotics? Are they being tempted? Do they need help? And he can't even do something as simple as that. And so, Your Honor, we are asking that you revoke him and sentence him to 8 years.
Your Honor, and the court is privy to its own record and also access to probation. He was never required to report in person. He was reporting by Zoom. And so this idea that him going in person versus not in person, the bigger question is, was he reporting? He has this missed report date in May. Now, I am just speaking, I guess maybe in, I don't want to say realistic, but just maybe everyday ways of doing business, right? You establish a relationship with someone, and as things happen or unfold, you document, or whatever the case may be. I do imagine that there are conversations that happen that are not documented. And that's okay to the extent that it's, I'm running late. Okay. And what I'm trying to draw out is that on this particular day, when he's supposed to test on May 1st, he's testified that I was supposed to be there in the morning. I was running late. I was allowed to come in the afternoon. The court is very well know if you're running late for a test, that can be used against you. You can be denied a reason to test, and that can be a violation. So someone gave him permission to do that. He's saying my probation officer did that. So if he's having contact with her on May 1st and there's no documentation of that, I get it if it's just simply a call of I'm running late. And that's fair. Those things happen, but that shouldn't be used against him to say that he didn't have contact. I don't know if that amounts to a formal meeting, right? A formal sit down or a formal Zoom call. But I think the idea of what we're trying to portray to the court is that he is trying to stay in compliance with probation. He's showing up for the test, and he did have contact in May.
So here's my question. My understanding is that this witness was being called because he said that I told him if there were any issues to reach out to probation. And so maybe my assumption isn't correct, but I assumed that this witness was going to be called to testify whether or not he reached out to her saying, hey, I have a problem maintaining my sobriety. I thought that's what her testimony was about or is supposed to be about. So that's what I'm looking for from this witness.
Just to clarify that, Judge, I think something got lost in the translation there.
Mhm.
What we're communicating to the court, just for clarity, is that when he got in trouble on June 1st, he called his probation officer.
But I mean, if you, and correct me if I'm wrong, but if you are charged with a new offense, according to the conditions of probation, you're supposed to reach out to your probation officer and say, I'm picking up a new case. He has pled true, and what he pled true to was the use of drugs. And then my recollection, if I'm wrong, please correct me. I don't hold it against anybody for correcting me. Sometimes I can be wrong, but he pled true to violations 2 and 2. And then he said, Judge, you told me if I ever needed any help to reach out to probation, and that's what I did. So I'm waiting for this witness to testify about his reaching out to her that, hey, I'm having problems maintaining my sobriety. If I am wrong in what I thought this witness was being called for, somebody please correct me. But that was my understanding.
If I may,
Yes.
Your Honor, I wasn't having any problems until this alleged robbery took place. When this alleged robbery took place, that's when I reached out to my probation officer, because to that point, I hadn't had any problems at all.
But the alleged, and I'm not taking this robbery as true, right? But the positive UA that you've pled true to happened in May. The alleged new case is on or about June 1st, 2025. Is the alleged new case on or about in May as opposed to June?
No, it's June.
No, that drug test is not on the correct day. That drug test was taken before I had the interview with the detective. I wanted to hurry up and get that done because I knew that it was possible that this detective could put a warrant out for my arrest. And I knew that once that I went up there and went to report with my probation officer, that if I got a warrant for my arrest, I'd be arrested. So as soon as this happened, I went up there to take that drug test. So that date, it must be in question, Your Honor.
So you're saying you didn't take a UA on May 1st, 2025?
I don't remember that date specifically. But I do remember running up there to take it because I asked my probation officer, or she instructed me to take the drug test several times, and I kept missing the appointment. And so this one I refused to miss. So I drove up there as fast as I could, got there right as they were closing. And
So you're saying they put the wrong date down. It didn't happen on May 1st.
so
Okay.
Judge, and if I could just address one thing, I specifically asked him the question if he ever reached out to probation regarding sobriety issues and letting them know that he was under so much stress that he was going to ingest narcotics, and the answer was no.
That is so, Your Honor. When
I think the inference from this is, Judge, I'm being looked at, I'm under stress, so I use some drugs. I reported and took my drug test. That's been documented. I spoke to my probation officer that day. I don't know if that amounts to a meeting or not. And in June, I also made contact, right? And also submitted to a test and made a payment. Those facts can't be disputed.
But here's the thing, for the court, it's not even, of course, you shouldn't be testing positive while you're on probation. But my understanding is that the whole reason for this witness testimony was not whether he reported on this day or that day. It was about whether or not he reached out to his probation officer to say, I'm under stress, I'm having trouble maintaining my sobriety, help me. Because he told me, and if I'm wrong, again, somebody correct me, we can have the court reporter read it back. He said, Judge, you told us we could reach out to probation for help. And I did that. And I haven't heard any evidence that he reached out to probation saying, hey, I need help. I'm about to use, or I'm struggling maintaining my sobriety.
And just to pick up on the court's point, I think the miscommunication comes because he has a different recollection of the timeline for the test. And what I'm trying to draw out is that when he got implicated in this new situation, he did call. That the timeline
How
of
did
that
he call
he
and
did
say,
call. And
I'm having trouble maintaining my sobriety?
he called and said, I'm being looked at.
No. Did he call and say, I'm having problems maintaining my sobriety?
He didn't handle the stress of that well. And he did use drugs, but he did show up for the test, knowing that he was dirty. He still showed up.
But no, did he? Because I'm trying to figure this out. Because he said that he reached out to probation because I told him if he ever needed any help to reach out for probation. And that's what he told me after he pled true to violations 2 and 2. So my question, and if it's yes or if it's no, it's just something for me to consider. My question is, did he reach out to probation and say, somebody help me, I am having problems maintaining my sobriety? That's what I need to know.
I would say the judge, you're correct that he did not communicate that. I'm just simply saying the reasons for that is I think the timeline was misunderstood. He committed this new offense, which he did communicate. After that, he said he spiraled a little bit and started using drugs, but still showed up for his drug test, even though he knew he was dirty.
But isn't the drug test before the alleged new number one?
There was one before and one after. I think the second was around June 16th or something like that.
No, both of these positive UAs are on or about May 1st.
So those, I don't believe that date to be correct, Your Honor.
Mhm.
And you are correct, Your Honor. I did not reach out for the purpose of help with sobriety at that point. When I found myself in trouble and I wanted to make record that this is what's going on, I needed some help. I didn't know who else to call about this situation that I was in. So I called my attorney. I called my probation officer and said, hey, I've been working for this lady. This thing is not seeming right. I feel like I'm about to get in trouble. I want to make record with you. Can you tell me what to do? And she did. That's the help that I called for initially. And I didn't make a call after that for help with the drugs.
And drugs are tough, Judge. They're highly addictive, and once you're on it, it's hard to get off.
I'm serious about my sobriety, Your Honor. And I've been going to AA classes and NA classes the whole time I was on probation. And the whole time since I've been here, I've still been participating in these classes on a weekly basis.
Okay. All right. Is there anything else from either side?
Nothing further.
All right. So the court is going to grant the motion. States you're asking for 8. How much time are you requesting?
It's a drug offense, Judge. We would ask for the minimum so he can get the help that he needs. I know TDC also provides some drug treatment programs. He's been participating in the jail since he's been arrested. And as he indicated, he was going to AA and NA while on probation. So I think he could benefit from some treatment. I believe that, again, a minimum sentence would allow him to get the treatment he needs in jail and come out and get on the right foot.
All right. If you'll go over the trial court certification with him, please.
This is not a plea bargain case.
No, you all just have to fill out. I'll make the
Oh, okay,
decision on, no problem.
This is your appellate rights form. She's going to on the record what your right of appeal is based on this particular hearing. I check this box, she's saying, don't check that box, she's gonna check the appropriate box and make a regular box for she check.
So what am I signing?
Where it says defendant. Ignore that check right there. She's gonna check whatever box she feels appropriate. I feel that one, but she's no, I'm gonna check the box and don't pay for that box. It's even unmarked at this point.
That-
Right. Yeah, just
This could be me signing that like we're going to prison.
no, this is you signing, saying, I understand what my appellate rights are. When I, you make the decision on it. This is saying, I know what my appellate rights are.
So we are now at a point where Your Honor is on the side on how am I getting in prison?
I believe so.
And if I don't sign this.
You don't have to sign it. Pass it here,
No,
please.
Your Honor, I don't wanna anger you. I've been.
Oh, no,
so
here's the
sorry.
thing. I'm not angry. I don't get angry.
I mean, not anger, but I want to cooperate with you, Your Honor.
No, you don't have to sign it if you don't want to sign it. What I can tell you, that document tells you whether or not you have a right to appeal. And I'm the person who makes the decision on whether or not you have a right to appeal. And so, once you sign that, I will let you know.
He's put his mark on it.
All right, thank you. So this is what the court is going to do. See, this is why you all shouldn't be checking the boxes, because the box checked is the incorrect box to check.
I didn't check that box, Your Honor.
Oh, I checked it. It's different by each county.
No, that's the incorrect box to check. So to attorneys going forth, the trial court certification of defendant's rights to appeal, you don't get to decide whether or not your client has a right to appeal. That's the court. So the court should be checking boxes, and you all sometimes check wrong boxes. All right, this is what the court is going to do. Court is finding violations 2 and 2 true. The court is going to grant the motion to revoke. The court is going to sentence you to 4 years in the prison, give you credit for any time served. The therapeutic community, there's to be no contact with Mark Daniel Lewis. There's a $2,000 fine. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yeah.
All right, good luck to you, Mr. Ross.
Can I ask a question?
Sure.
So been sentenced to 4 years CDC,
Yes.
and what about the aggravated robbery charge?
Need an expedited trial date.
All right, that's still pending, and just one moment with regards to that. Counsel, have you received discovery in that case?
I would need to check with my investigator, and make sure we have it all.
All right, let me just look and see what the cause number is for that. All right, so it's set for December 9th. So we'll see you back on December 9th.
Judge, yeah.
Just one moment. Yes. And then just. On Israel Cortez. Is Israel Cortez in the box?
Yes, yes.
If you can come down briefly, sir. Is he a Spanish speaker? I don't think, it doesn't, it's not listed on here as a Spanish speaker. All right, Mr. Cortez. Your attorney is actually in a jury trial, so we're gonna have to reschedule you and we'll recall you for next week, okay? Do you have any questions? All right, so we'll see you back next week. And again, if your attorney hasn't completed with trial, then we'll recall you for a different day. So you will be back on, let me see. Norma, put him down for November 3rd. We'll bring you back on November 3rd. And if your attorney wants you brought back sooner, he'll let us know. All right, thank you.
Okay, thank you.
All right, anyone else ready? Rogelio Favela? If you'll come down, please.
Good afternoon, Judge.
Good afternoon. Okay, Deputy Laura, you will appreciate this. The defense attorney who's on Zoom, I think their screen is from Harry Potter. All right. So who is the state on Rogelia?
Very good.
Hi. So where we are on discovery?
We do have all the evidence, Judge.
Okay, Judge, this is interesting because I'm appointed on 2025 CR 10700, which is the case in court today. Mr. Mr. Favela on October 9th picked up a new case, 2025 PF 40266.
Mhm.
On that case, he was appointed to Roberto Vargas.
All right, Norma, if you can make sure that Mr. Hopkey is on the possession less than gram case.
You
All
put me
right.
on both, okay?
All right.
And right now,
So has an offer been tendered?
no.
No, Judge, but I can give one.
All right, if you'll give an offer, please.
Okay. I'll also do a discovery acknowledgement.
All right, and Ms. Ferguson? I need a plea deadline date for the second week in April, I'm sorry, in November, please.
Eh,
All right, your plea deadline date will be November 10th.
Judge, could that just be another court date? Because obviously I don't have anything on the new case.
The new case, I believe, is a state jail felony.
Yes,
All right, so we'll come back on November 10th.
okay.
All right,
you.
thank you. All right, who else is ready? All right, Luis Andrew Medina III.
Downstairs, he is wheelchair bound and safe.
All right,
I
we'll
can't-
recall him tomorrow.
I can't, well, tomorrow I'm in Austin, Your Honor, but I can't proceed because I'm still waiting on evidence for the indicted family violence case. I do have evidence on the unindicted second degree CTD case. But
Family violence, where is his documents, his evidence?
It is uploaded, but again, I think we're having an e-discovery website issue that he can't see it, so I just told Mr. Hernandez if you can drop off a hard drive and I'll download all the evidence.
And I've explained to the state I can do that Wednesday since I'll be back in town on Wednesday. So I can bring that Wednesday if we can get him called a week or two.
All right. Deputy Laura, he's going to need to be here present in the courtroom. And this will be recalled for November 3rd.
Your Honor. Thank you.
Thank you.
So. Yeah. Oh, okay, thank you.
All right, who's next? Isabel Arias. Hello, good afternoon. All right, so what is happening here?
It's our first setting, I think. As far as I can tell, all the discoveries in place, I have access to it. I have an offer. I'm asking both prosecutors from family violence and from CTD to inquire with the victim to see what range of punishment they're looking at or sort of punishment. If I can give that information to my clients.
Okay.
She's charged with 4 felonies. She's never been arrested before in her life, and she
Mhm.
just had an incredibly bad day on this day. I'm trying to just get a better sense of what's at play.
All right, are there any mental health issues here?
She says no, but her affect indicates otherwise.
Okay. So you anticipate filing motions or?
I don't know, right? When I'm speaking to her, she seems fine, but I just want to dive in a little bit deeper at the jail.
All right, I need a 30-day reset for discovery, please. All right, and counsel, if you want to come back sooner than December 4th, just let us know.
All right, thank you,
So
Judge.
we'll bring you back on December 4th, but if your attorney wants you brought back sooner, he just needs to let us know. We'll have you brought back sooner, okay? Do you have any questions about anything? All right, thank you.
Thank you, Judge.
You're welcome. All right, anyone else ready? All right, Jimmy Vara.
Judge, I'm just waiting for a recommendation from the state on both of those cases. on,
Right, so your client is in custody?
yes.
All right, so you need to be in court.
Oh,
Yes, so have a seat. Your attorney will be here.
I'm sorry, Judge. Okay. And I also have Mr.
All right,
I
you'll
think
need to
they're
be in
both in
court,
custody.
counsel.
Michael Garza, they're both in custody.
Yes, so you need to be here.
Okay, thanks, Judge.
Thank you. Okay. Oh, Norman, can you call Christopher Ramos back, please? Hi. You have someone else on the docket.
Oh, excuse me.
Yes.
Yes, my understanding is that he didn't show up.
All righty, so we need to put that on the record.
Yes, Judge.
All right. Court is calling 2025 CR 011324 State versus Richard Wayne Esquivel. Could I have parties announced?
Lauren Espinoza for the state.
Christopher Ramos for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 2:41 p.m. The defendant has not made an appearance. Deputy Laura, did the defendant ever appear outside?
No, Judge.
All right, defense, have you had any contact with your client?
No, Judge, and customarily what I do is I reach out as soon as I get the appointment. I've reached out several times to him. He's never responded to me.
All right, state.
We would be requesting a bond forfeiture at this time, Judge.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you. Richard Esquivel on page 6. Yes.
Robin?
Here you are. Hello, Mr. Simmons.
Good afternoon, Judge. I'm here. That was you, wasn't it?
Yes.
Okay, I'm sorry, because I couldn't see the screen. I've spoken to Mr. Fish. We've been playing phone tag with his attorney in Terry County. Those charges sound like they're more serious. It seems like he missed court here in Bear County because he was in the hospital. Uh, we have not received an offer from the state yet, so we haven't requested one. But he tells me again, I haven't confirmed this with his attorney, so I'm going with him. But his attorney did call the office. So I have a number for his attorney, and I've been trying to reach him. It's just we're not sure what the status of his cases are in Terry County, and I don't know. He tells me that they're about to wrap those up, Judge, but I would think he needs to wrap those up before we can address the charges here. In Bear County. He also has some misdemeanor cases here in Bear County. I guess his previous attorney was Mr. Simpson. I'm not on those misdemeanor cases, so I'm not sure what the status of those would be.
All right. So
In
have
terms
you
of
had
this
it?
case, I guess it's the first time I've been able to meet with him. And we would defer to the court in terms of how the court would like us to proceed today.
All right, State, have you had a chance to speak with the defense?
I recall speaking to Mr. Simmons last week, but I'm struggling to remember what we talked about, so I'm trying to look up my notes.
All right.
It
So
was
if
not,
you all
it
are,
was not Mr. Fish.
all right. So the state can join you in a breakout room. State, are you able to join him in a breakout room?
Yes, sir. I don't think I've had to do that yet. I've been here, so.
Oh, Ms. Ferguson will give you the link. And I'm sorry, Mr. Fish, if you'll go to breakout room number 1, and Mr. Simmons, if you'll stay in breakout room number 2. Or at least go back to breakout room number 2. And the state will meet you there. All right, anyone else ready?
Yes. Found this, page 4.
That's my case, Judge.
Yes. Mr. Gomez, if you'll come down, please. Good afternoon.
Good afternoon.
All right. So what is happening with this case?
Judge, I've conferred with the state and my client. They've made us an offer. I want to go over some videos with my client. So we can get a reset to have the time to look at that and make a decision.
All right, Ms. Ferguson, if you can set this for the second weekend, November, please. All right, that will be your plea deadline date. On that date, you need to let the court know if you've reached an agreement. If not, your next setting will be a jury trial date. All right, thank you.
Thank you, ma'am. Thank you, Judge.
You're welcome. Anyone else ready? And Norma, if you can call Greg, Day Murray. All right, the parties on Carmelita Tapia. All right, in probation, there are no applications. Good afternoon. How are you doing?
Good, how are you?
All right, cannot complain.
Long day.
All right. All right, the court.
Or do you need first?
Court is calling 2024 CR 012738 and 2024 CR 011983. State versus Carmelita Christina Tapia. Can I have parties announced?
Lauren Espinoza for the state.
When Aguilera, attorney for Ms. Tapia.
And are you Ms. Tapia?
Yes, ma'am.
Counsel, have you received all discovery in each case and did you review with your client?
I have, Your Honor, and I have.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the true bill of indictment with your attorney? It shows what you're charged with.
Yes, ma'am.
All right, did you review those documents with your attorney?
Yes,
Did you understand them?
yes, ma'am.
And counsel, in each cause number, do you waive the reading of the indictments?
We do, Your Honor.
State, in each cause number, are you proceeding on the indictment as presented?
No, Your Honor, in cause number ending in 3-8, we are waiving paragraph B and proceeding on count 1, paragraph A.
Any objection?
No objections, Your Honor.
In each cause number, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am. Yes, sir.
All right, in cause number 2024 CR 011983, you're charged with an unauthorized use of a vehicle. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. And cause number 2024 CR 012738, you're charged with collision involving serious bodily injury as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have plea bargain agreements with the state, the court does not have to follow your pleas. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering into these pleas, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and
Yes.
enter into a plea in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, she is, and she was judged.
Ms. Tapia, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering into these plea bargaining agreements, if you're not a US citizen, you will be deported, denied re-entry and naturalization?
Yes,
Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Just one moment. And each cause number, did you review the plea bargaining page with your attorney? Did you understand it?
Yes, sir.
According to the plea and the cause number ending in 38, state is proceeding on paragraph A, waiving paragraph B. Punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. No applications. The state will take in consideration 2024 CC 739662. And there's to be restitution, if any, to Boy Long, BAOLUONG. And the cause number ending in 83, according to your plea, punishment is to be assessed at 365 days in the Bexar County Jail under 1244. There are no applications, and this will be a judgment satisfied. And each of those cause numbers, did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
And cause number 2024 CR 011983, how do you plead?
I'm not guilty, or not contest.
And in cause number 2024 CR 012738, how do you plead?
Not contest.
State any evidence?
Yes, Your Honor. In both cases, state offers states exhibit 1 in all attachments, and then also for the court's knowledge, there are some photos in the stipulation.
No objection. Your Honor.
All right, and have you had a chance to speak with the complainant?
Yes, Judge.
All right, thank you.
Thank
You may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
I would, he asked me, and I date, and, yes, I date, but I would not take. We can change that. WIM is in my.
In each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. In each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea bargain, Your Honor.
All right, and cause number 2024 CR 011983. The court is finding you guilty. The court will sentence you to 3 years in the prison. Give you credit for any time served. There's a $1,500 fine. Take in consideration 2024 CC 739662. There's to be restitution, if any, to Bao Long. And do you have any children?
I have two kids, 2 boys.
And who are they with now?
My baby's dad, my baby's father.
All right, and there's to be no unsupervised contact
Yes, ma'am.
with minors.
Yes, ma'am.
And based upon what I read in the police report, I'll recommend the therapeutic community. It doesn't increase the time that you're in custody, but if you have a drug or alcohol problem or mental health issue, it will help you with that. Is there anything else with regards to sentencing under that cause number?
No, Your Honor.
Deputy, I'm sorry, Cindy,
Yes,
what cause number did I read that for?
you said that was the 11,983, and you took into consideration the 739,662.
All right, there needs to be a correction. So that sentence is actually in cause number 2024. CR 012738. And And I'll state it again so there's no confusion. So under that cause number, the court is finding you guilty, 3 years in the prison, credit for any time served, a $1,500 fine, taking consideration 2024 CC 739662, restitution, if any, to Bao Lung, no unsupervised contact with minors in the therapeutic community. And then in cause number 2024, CR 011983. The court will find you guilty, and the court will sentence you to 365 days in the Bear County Jail under 1244. Give you credit for any time served, and the court will show that the judgment is satisfied. All right, and each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes.
you understand it?
Yes, ma'am.
And did you sign it?
Yes.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you, okay?
Thank you.
You're welcome.
Yeah, big sure.
Yes. All right, Mr. Simmons, let me have your client. Where's your client? Let me see if he's still.
He's still in the other breakout room, Judge.
All right, I'm moving him
And
to
I
the.
am parked, Your Honor, but I apologize. I'm in Guadalupe County
No problem.
bumping around.
He should be on in just a moment.
Yes, Judge.
All right, Mr. Fish.
Can you hear me, Judge?
Yes.
All right, thank you.
No problem. All right,
What is happening on this?
Mr. Simmons,
I'm sorry, Judge.
what is occurring on this case?
I've conferred with the state. There's still some. It seems as if this case got a little lost in the shuffle. Of course, he had previous counsel. The state was saying that they still wanted to get some additional discovery. They did get the police guide. They did convey an offer. I will. I've conferred with my client, and I don't anticipate it's something he would accept, but I have not conveyed it to him specifically in terms of him rejecting it. So I don't know if the court wants me to do that quickly before. But it seems as if probably he also needs to see the case, the charge that he's dealing with in Terry County as charged seem to be more serious offenses. And so I'm not sure how long he's going to be there in Terry County either, Your Honor.
All right, Ms. Ferguson, I need this reset for the third week in November, and that will be your plea deadline, counsel.
If I could be placed back in the breakout room with him so I could convey that the offer to him and then take it from there, Judge.
All right, what date? All right, so we'll be back on November 18th, and I will place you back in the breakout room with your client.
Thank you, Judge. May I be excused from that
Yes.
breakout room?
Yes, but well,
I'll
come
come. Okay, then I'll come back.
because I'll need to make sure that he is back and let them
Yes,
know.
Your Honor.
Well, you know what? I'm sorry. I'm being a little bit indecisive today. This is what you can do. Once you finish speaking with him, just have him get the deputy from there and let that deputy know that he's going to be recalled back on November 18th.
Yes, Your Honor.
And then they can have him excused from the breakout room.
Okay, Your Honor.
All right. And Norma, that'll need to
Nope.
be by Zoom. All right. Where is Greg? I don't see him. All right, and can you find out where that attorney is? Teresa Ann Max Vasquez. And I think we just have Greg Demarier's client. Oh, and also Shane Angus Collette. Could I see the violation report on that, please? All right, and Deputy Laura, if you could make an announcement when you have a chance for Shane Angus Collette, and also, just one moment, also for John Isaac Sabeta. All right. Court is calling 2025 CR 012107, State versus Shane Collette for the state.
Lauren Espinoza.
All right, this hearing was scheduled at 9 a.m. It is now 3:18 p.m. Defendant had not answered docket. Deputy Laura, did you make an announcement?
Yes, Your Honor.
All right, we're here on a violation report. And previously for the violation report, the court gave the defendant many attempts to get into compliance with pretrial services. He has failed to do so. He is currently on a PR bond. State?
Your Honor, we would ask for a bond forfeiture.
All right, the court will issue a judge's warrant and remand him without bond.
Thank you.
Thank you. Okay. All right, the court is calling 2025 CR 011376, State versus John Isaac Cepeda. Could I have parties announced for the record for the state?
Lauren Espinoza.
For the defense?
Greg Desmarais. Good
right.
afternoon, Judge.
Good afternoon. This hearing was scheduled at 9 a.m. The defendant did not answer the docket. Deputy Laura, did you make an announcement?
Yes, I did, Your Honor.
All right, defense, have you had any contact with your client?
I haven't, Judge. I was asked to take care of his case 2 weeks ago. He got out of jail. I did go down to County Court 14. He has a pending case there. They told me that's not set till November 17th. I came back to court. I didn't see him in there. And so I'll keep trying to reach out.
All right, state.
We would ask for a bond forfeiture at this time, Judge.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you.
Thank you, ma'am.
It's a sad football season this year.
You know, I'm putting it on the Broncos, Your Honor. We're just going to roll
Okay.
there.
We'll see what happens. I remember the days of the Orange Crush.
Come
Oh,
on, the
are you
Orange
being
Crush
used,
and those
Colorado?
uniforms were nice. That was a throwback. So
Yeah. All
but
right.
yeah, CU Dion said, it's like, I am dumbfounded. I'm like, dude, we lost 56-3. We're more than dumbfounded. So
Hey, maybe LSU will get us to be coaches. I will
Oh
tell
my
you,
God.
I would like to be the offensive coordinator. So
I can see it. I
All
can
right.
see it, Judge.
So if you want to do
telling you.
defense or special teams, I'll take the offense and
You
special
bring me
teams.
on, Judge. Let me handle the defense and we'll go.
Yeah, put me in, coach.
Put me
All right.
in. All right,
Hey,
Judge.
have a
Thank
good
you.
one.
You too, ma'am.
All right, tell Stephanie I said hi.
Yes, ma'am. I will. Take care.
All right, bye-bye. All right, Norma, do you have an ETA on that other attorney?
It's your partial here. Can I get you? I think I, she has executed earlier.
No. Just give me a moment.
Oh, Judge, I don't have it with me. I had it this morning. I brought the order form to my son popcorn.
Ah, hey, we got to do the popcorn.
I had it this morning, but we were super busy, so I didn't want to put it in your face.
You know, my mom, she used to take our candy to work. You know, they used to have the world's finest chocolate.
Oh, yeah.
Okay, those candy bars keep getting smaller and smaller.
Yeah.
And then I remember they changed it from that to Tootsie Rolls. And my mom was like, nobody wants to eat Tootsie Rolls at work. Why did they get away with that? And then the next thing you know, after that, it became M&Ms. So.
We did all kinds of weird stuff.
Mhm. Oh, and then you remember.
These catalogs, and you can
Yes.
get popcorn, chocolate, gift baskets, wrapping paper.
Yes.
Wrapping paper.
I was like, who did the wrap? You know, they should have done the wrapping paper back in the day. You remember when students would wrap their books
Oh.
and grocery bags? Can't do that now. Bring back the paper bags.
I went to a broke this corner. We had footy there, where you could wear your footies. So we had Commonwealth roll, let's see what else, the world's finest chocolate. We never did wrapping paper. I think that's kind of after my time. It's That's after me. Oh, yeah, we always had to pay. Like, okay.
Arlene, on this, they have Karen Corby listed.
Karen was second chair.
Okay.
And
That needs to be changed in the system.
yeah, and mine, there was a problem with the MAC and they just sent it off. This is for my PI. I filed it timely, but the problem is I'm like, because I hadn't gotten paid either. And I'm just thinking, oh, it's the auditor's office. And what I forgot to do, I did the orders, but I didn't do the final order to pay, which is now attached to the back.
All right. Norma, they have her listed not as lead counsel, so that needs to be changed in the system.
But yeah, mine just got approved Friday. So so you signed, I did everything right, but I didn't have a final order.
So
I needed an order
they
to
love the final order.
Mhm. Order to the order. So, and then I couldn't find all my originals on my computer. So thank God, I apply for file time, and on my appointments, they don't charge me, but on anything retained, they do. And they had this whole thing file stamped, and then they had one without the file stamp.
Oh,
So
wow.
they keep everything for me.
Oh, okay.
So I can always go back and grab anything I want.
And who is she? Was she waiting for someone, the lady who was sitting at the back?
She's related to one of them.
Oh, okay.
Okay.
All right, thank you.
Go ahead and take it to the back. Yeah, but now I can see.
All right, so we are just waiting for this one attorney. And Deputy Laura, do you know my high school 75th anniversary homecoming?
Are you going?
No, they're having it now. I'm here.
Gosh. Could have gone.
I remember my homecoming. I was senior princess. And that's, has a lot of history there. And my English teacher just celebrated her birthday, 93.
Wow.
Yeah. I loved my high school. Still remember our fight song. Oh, what did you do in band? What did you play? Oh my gosh, are you still able to play the clarinet? Ah. Mhm. Deputy Loris? Oh, wow. Today, I'm gonna write my first,
Entry.
my first lifetime story.
You're done.
I remember our teacher would make us do a journal. And you had to do it every single day. It would start out great. You're doing it every day. Then you get behind. Next thing you know, you're spending your last night trying to put in 3 months. And asking somebody, what date did that fall on? My mom was awesome. She would say, remember, we went to church on that day and we did this and we did that. And I'm like, okay, now remember. Norma, were you able to contact her? Yep. All right, so you all will come back tomorrow. Thank you.
Okay.